Ambassador Sergio here. Here.
Thank you, Sérgio Amaral, former Minister of Trade and Industry of Brazil. I'm now associated with Felsberg in São Paulo. I'd like to make two testimonies and raise one issue. First testimony is on Oxfam. I think that you have been modest in presenting the role by Oxfam. I think you have been modest because you have circumscribed to the subject of the meeting, which is Oxfam with respect to dispute settlement. But I think the role by Oxfam is much larger than that. And it reflects the importance of public opinion in international affairs and even in international trade. And I'll give you the example of the declaration on TRIPS and public health. Was minister at that time, was in Doha, and I can tell you that this declaration would never have been approved if it were not for the role Oxfam played in this case. I think it's a very good text case for the role of public opinion in international trade. The second point is the review of dispute settlement during the Uruguay round. It's a very curious situation. I was a negotiator. I negotiated this review on dispute settlement. I was the deputy representative of Brazil during the Uruguay round. And Brazil was very reluctant. Indeed, Brazil didn't want to enlarge the capacity and the range of action of the dispute settlement because we believed that this was another instrument by developed countries to open up the Brazilian economy. And now, on the other hand, at the same time, we were opening our economy. And we later realized that this was good for the country. But the dispute settlement was a very good instrument, and which now we resort to with some success. This shows the misperceptions, and Brazil is not the only case, misperception that representations in the WTO, in the former GATT and in WTO, very often have of their own interests. It's a very curious situation, and I think we have to take into account when we discuss issues at WTO. The issue I'd like to raise is of a different nature. We have been discussing the role by the dispute settlement mechanism within WTO. But there is one question that intrigues me, and we have been discussing this in São Paulo with respect to Mercosur. Mercosur created a court, a bit arbitral court, to resolve disputes inside Mercosur. But governments hesitate to allow for the private sector or to carry on complaints by the private sector to the appellate body or to the dispute settlement mechanism. And the result is that there is a contamination of many contention issues on the political relations among the countries. There's a overburdening of the political channels. And why is it not possible, instead of resorting to the court or the Mercosur court, just to resort to the judiciary? Because the norm, the treaty of the Mercosur, has been incorporated to domestic law. Why is it not possible? And it is. But we have never used that. And we are considering using that. When, for instance, Argentina created many restrictions and put many Brazilian products on a non-automatic licensing, that violates the norm of the Mercosur, but that violates too the domestic law in Argentina. And why don't we do this? My question is, why don't we consider this channel within WTO? For instance, when some time ago, I think there's no longer a problem, the United States thought Brazil was not complying with TRIPS agreement. TRIPS agreement is a Brazilian law. Instead of bringing this to WTO or resorting to a 301 mechanism, why is it not possible just to apply or resort to Brazilian court? This is a question which intrigues me I think we have a response in the case of Mercosur, but I still have some doubts to the extent this can be applied with respect to WTO. Thank you.
Thank you. Who would like to take the question?
On the WTO, as an American lawyer, it never occurred to me that we could have, that we could sue in Brazilian courts. It's good to know. Contact you, Renee. It would not be possible here, although politically the situation can be changed, but legally the WTO agreements are not part of our domestic law. And so anyone wanting to implement or to try to enforce a WTO right in our courts would have to find a parallel to it in the legislation that was passed by Congress implementing, as the U.S. saw their obligations under the Uruguay Round Agreements. And not everyone sees it the same way. And claim a violation of the statute itself, not of the WTO agreements. In fact, there is, for many years, been a doctrine in U.S. jurisprudence called the Charming Betsy doctrine, which a case back in the early 19th century involving a ship with that name. And the Supreme Court famously said that whenever there's an ambiguity in U.S. law, any dispute should be resolved to be consistent with the law of nations, which translate to international law today. And I think, insofar as the WTO has been concerned, the Charming Betsy has been sunk. I've tried it. Colleagues of mine have tried it, other lawyers. And the basic argument is that, against the position, is that the WTO and GATT before it, my case was actually under GATT, not the WTO, but it wouldn't have changed, is in effect visualized a poker game where you can play the game, and one of the things you can do is in effect violate it if you're willing to pay the penalty. You can decide to play it politically that way, and therefore there's not a legal right in a U.S. citizen to compel the U.S. government to act consistently with its WTO obligations if the U.S. government chooses not to do so. The U.S. government has the choice, as they see it, under the WTO agreement itself, to accept retaliation or pay compensation or whatnot. So it wouldn't work here. That's the long answer to it.
Any other question? Gentleman there.
Ian Swanson from Inside U.S. Trade. On the subject of the fact that it's sometimes hard for developing countries to effectively retaliate or seek compensation from developed countries, I think in particular, Brazil recently has floated an interesting idea in the context of the cotton case of withholding TRIPS concessions as a form of retaliating if the U.S. doesn't fully implement the cotton decision. I'm wondering what some of the panelists might think about that. Is this something that, how difficult would it be to do this under WTO rules, and is this something that you'd see as potentially a good development? Is this something to be worried about?
Okay.
Well, just some initial remarks. I believe David would like to comment on that as well. This, of course, the idea of cross-retaliation, it is an idea that was put on the table by Brazil, because today we have obligations not only in the goods sector, but as well in the services and TRIPS sectors. Of course, this is under evaluation in Brazil, because if we take, for instance, the services agreement, the GATS, in order to implement that kind of retaliation, we would have to change a law that basically, let's say, in terms of national treatment of market access, is open to everybody. So a service supplier in Brazil, a foreign service supplier, is entitled to provide the service, be from the European Union, from Mexico, or from the US. So from that aspect, I recognize, there are implications and very complex issues related to this kind of retaliation. And I believe the same applies to TRIPS, because as Ambassador Sergio Amaral mentioned, our intellectual property law in Brazil reflects absolutely the commitments we have under the TRIPS agreement. So once again, we would have to carefully think how a retaliation on TRIPS to a specific country would work. But on the other hand, we have to agree that it is a possibility, the cross retaliation, and that's why we brought to the table in this specific case of the Atlantic cotton. Thank you.
Just quickly point out that the DSU provides for that. There are restrictions. You have to carry out the retaliation that is possible, I think the term is, I can't remember the exact word, in the sector before you can move to another sector. It has been done. Ecuador did it in the bananas case involving the EC with regard to IP rights.
I'm not going to comment on the legal question, or is it my role to advise Brazil on the wisdom of doing such a thing? That's their decision. I simply wanted to point out that the fact that we've gotten to the point 10 years on where countries are considering such cross-retaliation only underscores for me one of the fundamental ironies in the system. David alluded to it earlier. What has made the WTO dispute settlement system effective in comparison with other international tribunals is two things. One, compulsory jurisdiction. Two, the legal authority that exists in the WTO treaty and that provides for the enforcement of WTO rulings. The enforcement is through a suspension of concessions, what my son and other journalists refer to as retaliation. And there are an increasing breadth of concessions. But think about it. Here we have a system that is largely devoted to lowering barriers to trade worldwide within a framework of rules that are supposed to facilitate trade on a fair basis. And the way in which we enforce the rules is by withdrawing concessions that have previously been made. Ultimately, that's self-defeating unless the concessions work and lead to not only an end of the suspension, but compliance in the party that has been complained against. I don't have a great alternative to this system, but I think increasingly we are seeing more and more members of the WTO thinking harder and harder about this irony and trying to look for other ways to do things. There's also the difficulty that smaller developing countries have when they win a case. They have the right to suspend concessions when another country does not comply. What if the prevailing country is a very small country and the other country, the responding country, hypothetically, is a very large country? Just how much is that large country going to be affected by a suspension of concessions from a small one? More likely, the small country is going to suffer more because of the distortions that will result in trade. This is what we should be thinking more and more about and talking more and more about as we try to think of how to improve the system going forward.
I have a slightly different slant, although I absolutely agree with the diagnosis of the problem. The disparity in size is what creates it. But I come back to my thought that it is really the instrumental value of the organization that's really the ultimate sanction. Because no one had to join it and anyone can pull out.
I agree with this, by the way.
It's good to keep in mind that Bob Hudak did some studies of GATT compliance. I can't remember his exact number, but it was pretty, he calculated that there was at least something close to full compliance in nearly 90% of the cases under GATT when the retaliation really wasn't possible unless the target of the retaliation agreed to it. It's probably pretty close or even better than that in the WTO. The first case to go through the system and through the appellate body was brought by Brazil and Venezuela against the United States on an environmental regulation involving gasoline. And Brazil and Venezuela won, and the regulation was changed. One of the early cases, one of the first 10, I can't remember which one it was now, was on textiles from Costa Rica, and Costa Rica won. And the U.S. appealed, and Costa Rica won again, and the U.S. complied. And it wasn't because they were afraid of retaliation from Costa Rica. I think, no one ever told me this, but it makes sense, it's my guess, is the reason was they might drag their feet more today, actually. But at that point, for the U.S. to defy the appellate body, or the DSB, on an adopted report, would have basically been a severe blow to the dispute settlement system that they fought so hard to get and forced down Brazil's throat and many other throats as well. That was their system, they wanted it badly. In fact, you could look at the implementing legislation, the 1988 Act, that gave the authority to the U.S. negotiators, and it gave them their marching orders, their negotiating objectives. And right up there at the top is dispute settlement. And if you read what they were required to get in dispute settlement, you would give the U.S. negotiators an A+ for what they brought back. That was what Congress directed them to get. And I think the U.S. had so much stake in it. And I think that really is the sanction. If the U.S. and the EU can play games, as I think they are in cotton and sugar right now, and to some degree they can, and stretch this out. The EC's been doing this with bananas for years, and they have more flexibility than a smaller member would have. I'd also say Brazil's got quite a bit of flexibility as well. Brazil's not Costa Rica. You've got a lot of clout. But that ultimately, that's the sanction. That's if you want the system to work, then you've got to play by the rules, and you're limited as to how much you can deviate, just as you're limited to how much you can safely exceed the speed limit on the highway without being pulled over.
I don't disagree with that. In fact, I agree with every word he said. But 2006 is not 1994 when the Congress of the United States passed the implementing legislation for the Uruguay round. I was one of the 6 original co-sponsors of that legislation in the House, and I recall the sentiment at that time, and the sentiment voiced by David was certainly our sentiment at that time. Flash forward to today. As an American, I am concerned that those in positions of decision-making authority in the American government are not necessarily seeing our national self-interest in the broader and longer term that would support the WTO as a trading system. I'm concerned that the debate on Capitol Hill especially is increasingly dominated by a narrower and narrower point of view that voices only the interests of protectionist U.S. sentiments. This is potentially perilous for the United States. This is a generalization. There are a number of members of Congress in both parties and on both sides of Capitol Hill who have been stalwart in their defense of the trading system and in their efforts to preach the systemic interests of the United States in having a system in which the rule of law in world trade is upheld. The United States is the biggest trading nation in the world. It certainly has a national interest in a trading system that works according to the rule of law. And one of the implications of that is that the United States, too, must be bound by the international rule of law in world trade. But there is a temptation from time to time to let one dispute or one decision dictate what policy is taken generally, and I think that's dangerous.
René Medrado, Pinheiro Neto, advogado, São Paulo, Brasil. I just would like to make a brief comment and trying to, well, James Backus touched on a very important point, which is imbalance of powers with regard to remedies. When you have U.S. and EC in a dispute, like the FSC case or the hormones case, just let them resolve. There's not really a problem. They will resolve through other means. David touched in another point, which is be careful with retaliation, because retaliation should not be, or if used, should be used with wisdom, and we should refrain from using it or saying that we have to use it. I agree with that too. The matter with imbalance of powers and the matter of retaliation comes exactly when you have countries with so different weights in terms of economy, in terms of presence in international trade. And then I come to the point of Guywan, which have identified 11 cases, and many of the cases would be brought by small African countries. But the matter is, they will be examining whether to bring a case under the shadow of the law. If the law does not have effective means or possible means for those countries to eventually go to the very end of the dispute, and I don't think that they should plan to go to the very end, probably they will not bring a case, and that will be a deterrent for them to bring the case. And then you have undermined an important element of the system for a considerable number of participants. So probably I agree with Jim that we should be looking into these more deeper now that we are actually in the end of, we have reached now the remedies part, and perhaps multilateral sanction or other types of sanctions could be envisioned. Thank you.
Thank you. Felipe Berra from Brian Cave and the BCI Institute. I have one question for Mr. Backus and another question for the whole panel. The question for Mr. Backus is about the Airbus-Boeing dispute. In 2005, when the U.S. terminated the bilateral agreement with Europe and they decided to bring the case, some people in this town said that the case was too large and too complicated to be handled by the DSB. I personally strongly disagree with that, and I'd like to know your views on this case, if you could. And my second comment, and also taking into consideration the comments from Professor Palmater, in terms of compliance, levels of compliance, the numbers from Professor Bob Hudak are extremely interesting, but I had the impression that he didn't take into consideration when he said that there were high levels of compliance in the GATT panels. Those panels blocked by the US and the EC, and some other panels that were withdrawn in the preliminary phase due to trade-offs that nobody will never know, the matters discussed in those meetings. And I don't know if you agree with that or disagree. And also, I'd like to make a question from that about the retaliation, or if you prefer, the suspension of concessions remedy, and if you have any ideas of other measures or remedies that could replace. I remember talking to you a couple of years ago or 2 years ago about suspension of concessions and some other ideas. Professor Chernovitz from GW had some very interesting ideas of how to replace the retaliation remedy. Suspension of rights was one idea, and some others were on the table a couple of years ago. Thank you.
Yeah.
I'll try to address your first question, and I'll leave the second question to David. First of all, I want to stress I offer no view on the substance or merits of the Boeing-Airbus dispute. I have no view. I have never expressed a view, and I'm not going to express a view today. Your question is whether the case should be before the WTO, as I understand it. There is no question in my mind that both the United States and Europe have every right to take this dispute to the WTO. Moreover, inasmuch as the dispute is won over subject matter that falls under the scope of the WTO treaty, they're bound in some fashion to take this dispute to the WTO if they want to litigate it internationally. That's a requirement of all WTO members under the WTO treaty. That's the compulsory jurisdiction issue that I mentioned. But no one is bound to litigate. I'm confident that the WTO dispute settlement system could reach legal rulings in this case as it has in other similar cases. I seem to recall I had something to do with some aircraft cases a few years back. I think David was there too, trying to persuade me of his point of view. So I have no doubt that the system can adjudicate the cases. The real question is whether it's in the interests of the United States and Europe to take this particular approach. My hope would be that they would find a way to resolve this dispute without going all the way through WTO litigation. Indeed, that's my hope for all disputes. And oftentimes that happens. My son, the journalist, would tell me if he were here today rather than in Baltimore that what I'm about to say is not news, Dad. But, and as a former journalist myself, I think he's right. It's not news. But what I'm about to say is I think the most important achievement of the WTO dispute settlement system. That is that every day in every market of every member of the WTO, decisions are made to do things or not to do things simply by virtue of the knowledge that there is a WTO dispute settlement system. Many disputes never arise simply because the members of the WTO know that there will be consequences. There's no way of quantifying that. These are all the drivers who stop at the red lights of the world trading system. And then, when a dispute does arise to the point where someone in government actually knows about it, almost always the dispute is resolved without ever reaching the stage of formal consultations in the WTO. And as the funnel narrows, among those where there are formal consultations, the majority are resolved without a request for the establishment of a panel. And when there is a panel, almost always the panel report as amended, if appealed by the appellate body and adopted by the DSB, is implemented in what the parties to the dispute think is a positive solution. It's only a handful of cases that are news. The question in every dispute, the one you mentioned and others, is how far should we go and what approach should we take? There are other alternative remedies in the dispute settlement understanding that could also be pursued apart from the usual course of WTO litigation.
On your question about Mr. Hudek's numbers, you're absolutely right. Particularly in the early years when panels are blocked, and I'd have to look what his qualifications were, but he was basically trying to allow for that, if I recall. And also, as the years went by, the GATT itself became more and more automatic in terms of preventing the blockage of the request for the establishment of a panel or an establishment of a panel and so on, and up through the Montreal rules, I think some of which really became part of the DSU. So while the blockage was a factor, and no doubt, my recollection is he tried to quantify for that, and there certainly was not complete compliance. He didn't say that. But what was remarkable was in a system that could have prevented zero, or resulted in zero compliance, there had been so many panels, every one of which had to have the okay of the target, and there had been so much compliance, every one of which had the agreement. So it was the high degree, I think, that was significant, which suggests that there's something other than fear of sanctions going on. Let me just touch on two things that have been talked of this morning. In the cotton case, the African countries, Mali, Benin, Burkina Faso, and so forth, has been mentioned. The U.S. is basically bent over backwards to try to help those countries. The cotton industry is worried sick about them. I can tell you this because I was at a panel in Georgia on the case in November, and they're sending people over, practically private cotton industry's foreign aid. The Oxfam factor has been enormously effective. The bad publicity the cotton industry got, not so much because of Brazil, but because of the impact of those subsidies on those poor African countries, has been very adverse to them here. And there's a lot of reform and a lot of momentum that's behind cotton reform, of getting rid of the subsidies. And the idea of getting rid of agricultural subsidies is driven in this country more by what it's doing to the countries that were not even involved in the dispute, except possibly as third parties, than the winning complainant in terms of the political force here. Jim mentioned the aircraft cases. It's interesting there is that both Canada and Brazil received the authority of the dispute settlement body to retaliate in an enormous amounts. I've forgotten the numbers, but they were astronomical numbers, because the aircraft trade, when they started valuing that, it got huge. They've never done so. But one of the things that's happened is, and it's related in this sense, is the publicity factor. Those cases generated enormous publicity in Brazil and Canada. Given where my loyalties were, we paid a lot more attention to what was in the Canadian press and whatnot. And I can say from the Canadian counsel that we had helping us in the case and just our own observations, that the publicity in Canada about what do you mean we're giving this company all of this money? It's actually had a result. Is one of the things that's happened as a result of the aircraft cases is those two aircraft companies are getting a lot less money from those two governments. And that's not necessarily a bad thing. This compliance occurs this way. There's a ventilation factor that goes on, as there has been with the cotton case here, of people saying, wait a minute, are we doing this? So that's got an impact it's a sanction in and of itself, a strong one.
Well, unfortunately, we have to break for lunch. I'd like to thank all the speakers for putting together such a great panel. And we will resume at 2:15, okay?
Good. I'll send you an email.
Very good. Very good.
Well, welcome to the third panel. We'll be talking about anti-dumping, one of the hottest issues in the WTO, at least for us that work on the subject. And I will refrain from presenting our speakers here, because you have in your program, you have the bios of each one of them, so I'm not going to waste too much time there. And I will only say that you couldn't get any better than this. We have just about every point of view represented here, including the Brazilian point of view and the way we applied our anti-dumping in Brazil. So I will start with Gilberto Moreira on my side, and I will remind my colleagues here at the table to please keep it under 12 minutes or so. I will remind you when we're about 1 minute to go. If you want me, I'll let you know earlier, and we can get started. Go ahead, Gilberto.
Good afternoon. First of all, I would like to congratulate Mr. Lima Campos, the IBCI Institute, and the Woodrow Wilson Center for setting up this conference. It's a wonderful opportunity for all of us trade specialists, mainly Brazilian trade specialists, that can exchange knowledge and experience with the Americans that are in the practice of a little more time. First of all, this panel will work with the negotiations on anti-dumping rules in general, and I would like to speak about something a little interesting, because as a Brazilian, most of the times we are throwing rocks on the U.S. anti-dumping rules, and some of the times not talking about our rules. And the system evolved with the time, and now developing countries are also in the role of appliers, of users of this rule. And now I'll be talking not only about rules, U.S. rules, but also a problem with Brazilian rules. The presentation is about when renewed discussion of the no-market economy. Well, renewed discussion because the no-market economy was a concept created in the 60s, in the 50s, sorry. And, well, when we had planned economies and market economies, and we had to sort out how to work in this kind of dichotomy of capitalism and socialism. Well, the world changed. Now we have a new world order. We have, of course, China, that is a major empire and a big player in the market nowadays. Well, since the introduction of the non-economic market concept, we have this working for, as I said, 50 years, and now we have only a dozen of countries under these special rules. Well, this would be not so important because transitional countries sometimes don't have so much importance in the worldwide commerce, but China is among these few companies and few countries, and is a very important players, as I said. And most of all is the country that is the constant target of anti-dumping investigations. Well, this discussion have been going on for a while about the no-market economy classification of China. The US have been discussing this. We had a few papers in the last 6 months discussing the necessity of using these rules. Brazil has also been discussing this. In fact, something like a year ago, President Lula signed a memorandum of understanding agreeing to consider China as a market economy. The idea of President Lula was to exchange this recognition for more trade with China, more exports to China, and more investment from China. Well, it's a hot topic, and China nowadays has 50 WTO members agreeing to consider China as a market economy. In the past, the structural difference between the capitalist and communist countries built a great case to have this kind of interface between these two different systems. The government control over the marketplace in these so-called planned economies made impossible to have the rules of the markets, the forces of the markets working, and to have the price formation. Then we had consequently overproduction, and we had also the necessity of these countries to have hard currency to buy foreign products. Consequently, we had problems of dumping in other countries. We have problems with below-cost sales. Well, because the GATT was developed by market economies, two market economies, we didn't have in the beginning a rule related to that. That's the reason, because in the 50s, the countries that were contracting partners of the GATT decided to introduce a rule related to that. It was the paragraph 2 to the complementary provision to Article 6, paragraph 1, that said that if you had a country where you had almost complete or complete monopoly of trade by the government, all the prices fixed by the government, then you could apply a different set of rules. After that, we had the first case using this new methodology was the bicycles from Czechoslovakia in the 60s, when the US authorities sorted out how to work with that and create this new methodology. The methodology was later on developed and introduced to the GATT rules at the time the Polish accession to the GATT a few years later. Well, how this works? In a regular investigation, as we know, the administrative authorities would ask for a few exporters to send in some questionnaires with information about their practices, and would adjust the normal price or construct this normal price in order to verify the margins, the dumping margin, fix the anti-dumping duties, or fix the all other rates rate. Nonetheless, if you are talking about these non-market economy countries, you'd use a surrogate country data, information from a third country, and use fix countrywide rate for the anti-dumping duties in this case. Most of the times, this duty would be higher than the duty normally used. But since we had different systems, it was impossible to fix prices, to see the prices established in these planned economies appear to be rational to use this kind of systems. This understanding of fairness follow with the Uruguayan round, and you have in Article 2.7 of the anti-dumping agreement, we had a specific provision remembering what was said before in the GATT. Well, while there were some planned economies, it was okay to use this kind of rules. But now that we have these transition countries, these formerly planned economies as transition economies, when you have the private sector finally appearing and having then the forces of market working, well, it appears that it's a different scenario, and maybe there is no way to apply that provision of the anti-dumping agreement or the GATT anymore. Well, this was just an introduction, because these are articles, they would work for the former planned economies, but the biggest point now is to talk about China. And China, as you know, in the accession to the WTO, in its protocol to that of accession to the WTO, agreed to be considered as a non-market economy for 15 years. Okay, they agreed to do that, but there is an if the producer under investigation cannot clearly show that market economy conditions prevail in the industry producing like products with regard to manufacture, production, and sale of the product. That means if the market conditions prevail, you are supposed to use normal anti-dumping rules instead of this non-market economy concept. Well, the problem is also that China has developed an economic model that is called the socialist market economy, right? And the success of this model produced a lot of surpluses, of influxes of foreign direct investment, and a lot of problems for the domestic industry in other countries. This problem made China be the best target for, or not the best, but the target for anti-dumping investigations. Well, but what we can see nowadays that what's the point for using this methodology to China? Because the real problem with this new system developed by China, this third way of seeing the economic model, is that it's not the model per se the model per se, but the fact that we have a lot of subsidies that makes sometimes difficult to know how is the right price, the problem with transparency in the economy. Even the government of China sometimes doesn't know what are the correct, how the economy is growing. And most of all, the problem with accounting principles. They don't have accounting rules working for any company, only some companies. Well, talking about that, we can see what makes a difficult application. It's not the fact of sometimes you can see that there is no meaning to have this kind of methodology anymore. If being possible to verify the market conditions, we know that Chinese exporters are subject to regular anti-dumping rules. This, we know, increases the burden of investigation authorities that have to confirm the operation of the market regarding each of the Chinese exporters that have means to defend themselves. This creates a kind of a burden to the administrative authorities that need first to look if the Chinese company is under market conditions, to later on ask for questionnaires and to adjust the normal price or construct this normal price. Therefore, since we have these reforms going on in China, and since the Chinese companies are already being able to show that they are under market conditions, well, maybe the use of this methodology is not the right way anymore. Maybe we could, instead of using this kind of methodology, work with the Chinese government, with the Chinese companies, to create somehow some way to have transparency, to have good accountability rules, accounting rules, and to solve these problems of transparency, as I said. We could use, as a way to do that, we could use as a bargain chip recognition of some sectors of the economy as having market conditions. This would help the other countries to discuss and to work better this kind of things. This would result in less resentment by the Chinese and open flows of trade. Therefore, as I said, when Lula last year recognized China as President Lula recognized China as a market economy, the private sector was outraged. They said that it would be impossible, that it would be very difficult to work with the Chinese companies, to work with the anti-dumping rules. Well, maybe it's not that bad. And maybe Lula took the right decision, because he is looking for higher flows of trade between the two countries, to work towards more foreign direct investment. And then the way is cooperation to work with this problem. Well, I believe that the national anti-dumping legislation should take a further step, liberalizing, eliminating the non-market economy concept, at least recognizing the non-operation market in select sectors as a transitional measure until it becomes possible the full elimination of the methodology. Because as I said, nowadays we don't have the non-market economies anymore as you had in the 50s. We have marketings working, sometimes bad, sometimes working with some fails, but it's a marketing working. Well, and if I'm wrong, if this is not the case, then we should work in the negotiations tables, working in a new way to see China, maybe changing the Article 2.7 of the anti-dumping agreement, because that text doesn't work anymore to China. Well, thank you. This was my remarks. These were my remarks.
Thank you, Gilberto.